Hi, I'm Jeff Palomo with Palomo and Associates, and welcome to the three secrets to protect your family and your legacy. I look forward to being with you today. Before we get started, I want to start with just a little overview. This is a workshop that is a pre-planning workshop, an estate planning workshop for people who want to plan ahead. So if you or a loved one is going to need skilled level care in a nursing home in the next 6 months to a year, please call the office and ask to get the Crisis Medicaid workshop. This workshop is a pre planning workshop to plan ahead. All right, excellent. First thing before we get started, I want to talk about the wonderful team at Palomo and Associates. I could not do what I do without this incredible team standing behind me and with me, and I am just so honored and humbled to have them there. So I look forward to you meeting some of the members of our incredible team as we go through this process. So let's talk a little bit about Palomo and Associates. So what makes our firm unique is that we educate. We educate so that what happened to my family doesn't happen to yours. We are a boutique family field experience. We put clients' needs first, and we are a CELA law firm. CELA means Certified Elder Law Attorney, and I am a CELA in the state of Pennsylvania under authorization of the Pennsylvania Supreme Court. So we are very honored to be able to have that distinction and designation. What is our purpose? We educate so what happens to the Belomo family doesn't happen to yours. And our goal at Belomo and Associates is to help 15,000 families protect 2 billion in assets. What is our guarantee? If you are not 100% satisfied, we will make it right. Please just let us know and we will make sure that you are taken care of. A little bit about me. So I was one of the unfortunate ones. I got a phone call 2 weeks before the bar exam telling me that my mother was sick. I rushed out to Pittsburgh only to find out that she had advanced stages of cancer. The surgeon said to us, look, I can do the surgery better than anybody, but there is a chance that she's going to need help. She's going to need assistance. So you should start looking into in home care, hospice, assisted living, nursing facilities. Know your options, know what's out there. So right away, we start asking questions. How are we going to get mom the care she needs? Is dad going to be okay? Is he going to lose the house? Is he going to lose everything that he worked for? How are we going to protect them? Can we do something now? Should we have done something sooner? And the surgeon said, I don't know. I do surgery. All right. He said, you should go see a lawyer. So I did. I went to a law firm, paid $400 for the consultation. At the end of the hour, I said, so what are the answers to the questions? How are we going to get mom the care she needs? Is dad going to lose the house? Should we have done something sooner? And the lawyer said, well, you have to pay me for that. I said, I did. He said, no, you paid to meet with me. That $400 was a consultation fee for me to learn about your case, put a solution together for your family. And the solution that your family needs is $15,000. And if you step foot out of the office today, you forfeit your $400 consultation fee. To which I said, goodbye. And I left. And I walked out the door. And I went to another law firm. And what do you think happened? Yep, same thing. Now I am out another $400. Still don't have the answers to the questions. Still have no idea what we're going to do to protect the family. Now, the lawyer's belief was all we have is time and knowledge, and you have to pay for that. And if I give you the answer or the solution, you don't need me. And I disagree. So I made a promise. I promised my family in that hospital room what happened to us would never happen again. I've been very lucky. I did pass the bar exam on that first try, and I got ESQ after my name. I was able to get a master's in taxation, which puts an LLM after my name. I did get the CELA designation, which puts a CELA after my name. You know, the only thing that I really needed after my name? A job, a job. Because I was broke and I got a job. And when you get a job at a law firm, your job is to make the partners money. So fast forward 2009, I'm leaving the client meeting. I put my hand out. I said, well, ma'am, that would be $400. And I burst into tears. Why did I burst into tears? Because I became one of them. I did exactly in that moment what I promised my family and myself that I wouldn't do, and it hurt. And I quit my job. I said, I'm going to go open up an elder law firm that educates for free and gives people the information, the knowledge that they need. And all of my mentors said, Jeff, you won't make it. All we have is time and knowledge as lawyers. If you give it away for free, you're going to go broke. So one of my friends even said to me, hey, in 6 months, I'll be happy to hire you when you need a job. I'm very happy to say that I never needed to go back to them for a job. And here we are over 15 years later, still providing free education. Free education in estate planning or pre-planning, which is this workshop, the crisis Medicaid planning, special needs planning, life care planning, post-death administration. We offer free education so that you can learn the information that you need so that when you're in a crisis situation or when it happens, you can act calmly, rationally, and make the best decisions for you and your family. So I'm very proud of that. And to this day, we are still able to do that. So welcome to our education. And that was a little bit about me and how I got into elder law. At the end of the day, it is all about family. So I promised you we were going to talk about the 3 secrets to protect your family and your legacy. So secret number 1, it's not about death and taxes, right? When I say to people in a room, what is estate planning? They start thinking all about death tax. So let's take a look at this, all right? The federal estate tax limit currently says that you are allowed to die with $13.99 million and have no federal estate tax that you have to pay. And if you're married, it's another $13.99 million. Now, look, I'm not a mathematician. So how about we round that to 14 million? And we say 14 million plus 14 million if you're married is 28 million. Do you want to know how many clients we represent at Paloma and Associates that have more than $28 million? Let's hear it. Yeah, none, right? Zero, zip, zilch. So that is not something that we have to worry about. And please notice that I didn't even mention anything about an annual exclusion gift where you can get $19,000 away per year. It doesn't matter. If you don't have anywhere near 13.99 million, you do not need to worry about it. Now, please note, we are recording this workshop in 2025. So that is what the current estate tax limit is in 2025. As I stand here today recording this workshop, on January 1st of 2026, the federal estate tax limit is set to come back to $5 million plus inflation, which they're guessing is going to be somewhere between 7 and 8 million a person, or 14 to 16 million for a husband and wife. You want the good news? I'm still going to probably have 0 clients that have that kind of wealth. So even if it comes back down, it isn't going to impact anything. I'm hearing from people who are in Washington that that's one of the first things Congress and the president wants to address, and changing it to bring the limits back up, which doesn't surprise us, right? Who are the people who have the biggest federal estate tax problem? People in Washington who are in Congress and the president. So I assume that now that they have control of the Congress and the presidency, they're probably going to increase that amount. But either way, 14 to 16 million for most husband and wives is going to be completely fine. So let's agree that we don't have to worry about that. Now let's talk a little bit about Pennsylvania inheritance tax. Pennsylvania does have an inheritance tax, and it taxes on the wealth that you transfer at death, and it depends on the relationship of the person who is receiving the wealth. So, if you die in the state of Pennsylvania as a resident of Pennsylvania, the estate gets taxed at a 0 rate if it goes to a spouse, 4.5% to lineal descendants, that's children, grandchildren, parents, grandparents, 12% to siblings, and 15% to anyone else in the world, including those lovely nieces and nephews. So we know what the tax is. It taxes on the first dollar that you transfer to those individuals. Now, believe it or not, that is actually nothing more than having like a mosquito bite, right? You get a bite and a mosquito bites you and it bothers you, it's annoying, it's itchy, it goes away, maybe you get bit again, it's annoying, it's a nuisance, but it's nothing more than that. And that is the Pennsylvania inheritance tax. The good news When assets are subject to the Pennsylvania inheritance tax, that means that the person who died was in control of their money at the time of their death. That means that the person who receives the money, the beneficiary, gets a step up in basis so that they don't have to pay capital gains tax. So let me give you an example. If my dad puts my name on his house that he bought in 1976 in Pittston, Pennsylvania, that he paid $20,000 for, I now own that house. My basis is the 20,000 that he had in it. Yes, if he passes away and it was in my name for more than 1 year, I will avoid the Pennsylvania inheritance tax. But here's the problem. When I sell it, I will have to pay the fair market value, which is 200,000. That's what I sold it for, minus 20, which is $180,000 of capital gains tax at 23.8%. But had I had that in his estate, whether it be because he had it in his name alone or whether because it was in a trust that he controlled, I would have paid 4.5% on 200. But then when I sold it for 200, I would have paid zero in capital gains tax. So that's a long-winded way of saying at the end of the day, we want to make sure that we protect ourselves and our families. And we don't want to burden our kids with a huge tax consequence that they don't need. So the inheritance tax is a nuisance tax. It allows us to get the step up in basis for the kids. The only way to avoid it is to completely give up control. Put the money in their name. If you don't learn anything else from this workshop today, I want you to remember one thing. The most important thing in estate planning is control. All right, all together now. The most important thing in estate planning is what? Control. So I don't want you giving up control. You have worked far too hard for the money that you have to run the risk of giving up control. And besides, your kids don't want that tax burden either. So that's what we're going to talk about. The federal estate tax and the inheritance tax are not things that we need to be concerned about. It is not what we should be focused on. Okay? Remember those photo albums in the old days? I vividly do. I remember being at auctions and watching siblings literally fist fighting over who's going to get the photo albums. We're not fighting over that anymore. Oh no. Now we're fighting over who has access to the passwords, the online pictures, who can get into the bank accounts, who has all the digital stuff. That's what we're fighting over now, right? The landscape has changed. And this didn't become really apparent to me until I bought two practices in 2019 from two wonderful humans, practicing attorneys in the estate planning arena. And when I started to look at their documents, I learned that the forms that they used in 1982 were the same forms that were used in 2019. Now, let me ask you, were digital assets a thing in 1982? Of course not, right? Was asset protection a thing in 1982? Of course not. And that is why at Paloma and Associates, we update our documents several times a year. We constantly get updates. We will notify you of those updates, and I'll certainly talk more about that later. But we need to make sure that they're up to date and that they have the language in it that they need. Not to mention, banks often tell us that they will not accept financial powers of attorney that are more than a year or two old. So those forms from 1982 certainly weren't going to work. And we constantly revolve and tweak the language. So we want to make sure that's all up to date to include for those digital assets. All right, now, the biggest crisis that we have coming, biggest threat that most of us don't even know about is our healthcare costs. So I have a bill up here. It's from the beginning of 2022. So it's a couple of years old now. But I did that because if I use today's dollars, a lot of you wouldn't even believe it. So here's a bill, husband and wife. One of them is in the nursing home, and they have been receiving this bill. And the average cost currently in the state of Pennsylvania for 1 month in a nursing home is $14,676 a month. Now you'll notice that this bill is about $27,000, right? We're looking at a month and a half in a nursing home. Now, how does that happen? Well, because there's a lot of things that get added to these bills. It's very expensive to run a nursing home, and we have to make sure that they get paid. But my question to you is, where's this money come from? How are we paying for this bill? Right? With the average cost of a nursing home at 14,676. And when you look at this, you'll see something on here that's called a dolphin mattress. Right? Now, I get what that is, but when you're paying that kind of money, there should be literally dolphins swimming in your bed alongside you, and you should get to pet them. Right? It's crazy. And the problem is the system is broke. I want to be very clear right now that it's the system that is broke. The facilities work very hard. They do great work. They do their best to care for our loved ones. But our system is broke and it needs to be fixed. Currently, there are three ways that people's long term care typically gets paid for. One is veterans benefits. I'm not going to spend a lot of time in this workshop today talking about veterans benefits because the truth is, in 2015, the Veterans Administration kind of removed the ability for us to protect assets or to do things for the Veterans Administration in order to get veterans aid and attendance benefit. Now, in order to get that aid and attendance benefit, a veteran who served at least 90 days, one day of which was active wartime, has to be spent down to, let's call it $160,000 of assets. We can't do pre planning or trust planning now unless we do it at least 3 years ahead of time. So they changed it so that it was more like Medicaid. Medicaid is a 5 year look back, but for the VA, it's a 3 year. And if you're going to do it, you have to use a trust that you give up control. The only people who have to do that kind of trust are people who have more than $28 million for a husband and wife, or more than $14 million for a single individual, and tell them that they should give up control of their money to receive a benefit that might be, $2,000, $2,400 when the bill that they're facing is 14,676 a month on average. So that benefit is really not even available anymore. The next benefit is something that is called Medicare. So we all are taught as we grow up that we pay into this system. We turn 65, we get health insurance. The health insurance will pay for us and keep us protected for the rest of our life. And to some extent, that is true. But let's take a closer look at it, right? Let's say that I have a heart attack today. I have a heart attack, I get rushed to the hospital, major surgery, put stents in, do everything that they need to do in order to be able to help me. I stay in the hospital for about 3 weeks. I get a little stronger. Ultimately, I end up going to a rehab facility, a skilled facility that's going to rehabilitate me. My Medicare benefit will pay up to 100 days. That's assuming that I was admitted for 3 consecutive midnights. Let's just assume I was. I was in the hospital for major surgery. I was there for 3 weeks. Now I go to the rehab hospital. As long as I'm able to do the rehabilitation, they will continue to pay for me up to 100 days. If I have a supplemental policy, I might not even have a copay. I might have zero out of pocket. That is how we believe the system works. That's how it should work. All right. What if I have a stroke? All right. Same scenario. Had a stroke, get rushed to the hospital, surgery. Now, what's one of the side effects of a stroke? Yeah, I might lose use of my extremities. I might get a little brain fog. I might lose some cognitive ability. Now, let me ask you a question. How likely am I to be able to rehabilitate and do occupational therapy, physical therapy, if I don't have use of my extremities or if my brain is foggy? The truth is, I'm probably not. So now I go from paying next to nothing to set 14,676 a month. And that happens quickly. You will get notice on a Tuesday, and as of Friday, your private pay. Our system picks winners and losers based upon whether you have a heart attack or a stroke. That is crazy. That is absolutely crazy. The system is broke. All right. So the last way that we can sort of pay for the care is something that is called Medicaid. Okay. Medicaid is another way to provide care. And one way to get qualified is that you are completely spent out. You have no assets. So for a single individual in the state of Pennsylvania, you have to have under $2,400 or under 8,000 in assets. Let's just call it 2000 for today. Again, remember, I'm not good at math. And we want it to be around 2000 so that the state isn't going to be able to capture that money back or claw that money back. So we're going to go $2,000. What is included in that $2,000? All right, help me out here. Is checking included? Yep. Savings? Yep. Cash value and life insurance? Yeah, you got it. The retirement account for the person needing care? Yep, absolutely. So essentially, what did I tell you is included? Everything, right? Everything's included. And I know some of you are thinking, well, no, wait a minute, Jeff. Well, wait a minute. Hold on a second. What if I exempt the house with the intent to return home? I read about that. My neighbor told me. All right, well, let's think about it. If mom has spent down a $2,000 and she exempts the house with the intent to return home, who's paying the carrying cost of the house? Who's paying for the taxes? Who's paying for the utilities? Yeah, the children. And the children are paying because they think what's going to happen when mom dies? They're going to get the house. You know what? That doesn't happen. There's something called a state recovery, where the state says if we pay for your care, we get to claw back or we get access to the money that we paid out for your Medicaid benefits to the extent that your asset went through probate and to the extent that it's in your name alone. Now, is that house in your name alone? Yeah, I exempted it with the intent to return home. So that means that the state gets to lien that house up to the amount of care that was provided. At the end of the day, we didn't protect the house. The kid didn't end up getting it because it was liened up to the amount of care that was provided. The kids paid all this money out. They might get that reimbursement back, but they still didn't get the house. They still didn't get what they were hoping to get. So it just doesn't work out. It's not much better for a married couple. Remember, the individual who's receiving the care has to get spent down to 2000. The spouse who's living at home is allowed to keep the house, the car, the spouse's retirement account, the spouse living at home, the community spouse's retirement account. Then we put everything else in a pot. I don't care if he owned it, if she owned it, if it was jointly owned. I don't even care if there was a prenuptial agreement. The state of Pennsylvania was not a party to that prenuptial agreement. So what that means is now we have to put it in a pot. The community spouse gets to keep half of the pot, right? But no more than, let's just call it $160,000. So the most that they can keep is 160, and on the low end, let's call it 30. Now, again, if you're in crisis, a loved one's going to need a nursing home in the next 6 months to a year, please watch the crisis workshop. We'll give you to the date numbers. For the pre-planning workshop, I'm just going to use generic numbers because it's going to change every year anyway. I just want you to understand concepts. So now the community spouse realizes that the most they're going to keep is, let's say, 160 grand. So if that pot of money was 500 grand, they have to get spent down from 500 to 160. Or if the pot was 200,000, they only get to keep 100, right? So at the end of the day, the spouse living at home is scary. They lost a lot of money that they were hoping to be able to use to live for the rest of their life. So another way to qualify for Medicaid and to get the benefits is to plan ahead. So we're going to talk a little bit today about how to plan ahead to make sure that you and your family are taken care of. Now, the good news in the state of Pennsylvania is that almost all facilities accept Medicaid. You can go to the crisis workshop to learn more details, but all the facilities in York accept Medicaid, other than one, and frankly, it isn't one of the nicer ones. The nicer homes in York County all accept Medicaid. That's the Brethren Home, the Lutheran Home, Normandy Ridge, Misericordia. They all do. Why? Because that's the way the system was built. We never expected people to be able to come up with 14,676 a month forever. So the government said, we're going to figure out ways to assist. But you need to work ahead. You need to plan ahead in order to be able to do it. And so we're talking about how we're going to plan ahead. Secret number two, you need the right tool for the job. If I had a quarter for every time that I said to somebody, what do you think of when you think of estate planning? And they said, a will. What's the one document everybody needs? Everybody says a will. All right, let's think about it. What does a will tell us? A will tells us what happens when you die, right? That's the easy part. And I'm trying to be funny and not funny. That's easy. How am I going to make sure that when you lose capacity, your bills are paid? How am I going to make sure that if you do end up needing a long-term care, that your family is protected? How am I going to make sure that when the assets transfer to your loved ones, the money's protected for them, right? That's what estate planning is. There's even a Pennsylvania statute called intestate succession that tells us if you don't have a will, the money goes to the closest living relative. So in reality, a will is probably the least important document that you're going to get in your estate planning portfolio. But that's what everybody thinks it is. That's what everybody says. So I want you to beware of somebody who says all you need is a will. With attorneys, why does that happen? Well, there's two main reasons that happens with attorneys. One reason, the attorney is a general practice attorney. They do everything. Meaning, on Monday, they might do landlord tenant. Tuesday might be criminal law. Wednesday might be wills and trusts. Thursday might be criminal. Friday might be family. Who knows, right? In their arsenal for estate planning, they have a will, a financial power, and a medical power. And in the medical power, they have a living room. Those are documents that if you are incapacitated, you're authorizing somebody else to make decisions on your behalf. Essential. I have been known to argue at the end of the day, I think the most important document everybody needs is a properly drafted financial power of attorney. And I think it's very important to have a medical power of attorney in place as well. But that attorney basically has a will to provide. He's a general practice attorney. He has a will. He might include the financial and medical power as well. Probably a form from 1982 that he hasn't updated. Beware of him. He's not somebody who does this on a regular basis. Or you might get the opposite extreme. Now you're dealing with a tax attorney, somebody who has an LLM in taxation like I do, and they're looking for people that have tax problems. People with more than $14 million or more than 28 million for a husband and wife. Again, how many clients do we have? Zero. So if those attorneys see that and they can't do a tax trust, they immediately say you need a will. Be aware of that. Be careful with that, right? Wills do not protect assets during life or after death. So we're going to talk about how we can actually get the documents in place that will allow us to qualify for benefits, that will have updated digital asset planning, that will avoid probate and will provide asset protection. Right? Wills mean that an asset is in your name alone at the time of death. A will must go through probate. Probate is the legal process by which we carry out your wishes. And what is ultimately, at the end of the day, the one thing that people don't like about probate, right? It's attorney's fees. So we're going to teach you how to avoid it, how to keep the cost down, but how to do it in such a way that you're protecting you and your family. So we're going to talk a little bit about trust. Trusts are a legal contract between three parties: the grantor, the person who creates it; the trustee, the person who controls it; the beneficiary, the person who receives it. It's just a legal document that explains the relationship between those three people. Now, if you had your pick, who would you want to be? All right, yeah, I heard it. I heard it. You said beneficiary, right? You're just going, show me the money. All right, okay, I'll give you that. Now, if you can't be the beneficiary, who do you want to be? Ah, control freaks out there. I hear it. All right, trustee, you want to be in control. I get it. All right, I'm going to ask one more time. If you could be anything you want to be, who would you want to be? Well, there's only one left, so you're probably all yelling, grantor. Let me ask, who gets to decide what the beneficiary gets? Grantor. Who gets to decide what the trustee controls? Grantor. All right, one more time. If you could be anything you want to be, who would you want to be? All three. You want to be all three. Now, why didn't you say that? You didn't say that because you didn't think you could. What we know about trust, We know about trust from the late 90s. In the late 90s, the federal estate tax limit was $600,000, or for a married couple, $1.2 million. Now it's 14 million and 14 million. Do we agree that 1.2 million and 28 million are two very different circumstances? Heck yeah. Now, when it was the lower number of 600 or 1.2 million, we were doing a lot of tax trusts. There were a lot of tax trusts that were being drafted, irrevocable tax trusts, where the grantor could not be the trustee. They could not be in control. You could not have say over what happens. You had to file separate trust tax returns, pay higher trust tax rates. Now, let me ask, if you had to give up control of your money, how excited are you to do it? You're not. Remember, I told you earlier, control is the key. So what we know about trusts, we need to forget. So I'm going to ask you for a few minutes to just kind of knock all that information out of your head, stay with me, and stay present. I'm going to teach you today trust, that because we don't have that kind of wealth where you can remain in control, you can be the trustee, you can be a beneficiary and have use and enjoyment during your lifetime. We can still get the kids to step up in basis of death. You can still file on your same 1040. You can still pay your same individual income tax rates. That's what we're going to teach you today. All right. So, by way of introduction of a trust, I want to show you my Radio Flyer red wagon. All right, my red wagon. Now, how many of you had one as a kid? I did. You're darn right, I did. And what went in it? Whatever I want. G.I. Joe figures, rocks. My sister used to make me carry her Barbie dolls. But anyway, I would carry them right behind me. I was proud. They were so important to me. I didn't want anyone to touch the stuff that I had in my wagon. May I introduce to you my trust as an adult? It's still a red wagon. It still has the things that are most important to me. It might be my house. It might be my investment accounts. I still have them right behind me. I'm still proud because this is what's important. The concept hasn't changed, and that's why we teach trust through this concept. So, what I'm going to do is I'm going to give you an example of how this works. If this house is in my name, Jeffrey and Whitney Belome, who can live in it? Jeff and Whitney. Who can sell it? Jeff and Whitney. Who can buy another one? Jeff and Whitney. If we live in it 2 out of 5 years as our primary residence, we avoid the capital gains tax. This is exactly how the rules are today. So that should sound familiar. Now watch what I'm going to do, okay? Jeff and Whitney Belomo, trustees of the Belomo Family Trust. All right, what did I just do? I put the deed to the house into the wagon. All right, it's in the trust now. Who owns the house? The trust, all right? Who controls the trust? The trustee, Jeff and Whitney. Attached to the handle of the wagon is the trust document. The trust document explains the relationship between the three parties, and it says Jeff and Whitney can live in it, Jeff and Whitney can sell it, Jeff and Whitney can buy another one. And if they live in it 2 out of 5 years as their primary residence, they avoid the capital gains tax. All right. So that sounds an awful lot like it did in my name, doesn't it? Yes. Why does it sound an awful lot like it? Because it's the same thing. Exactly the same thing. Now, with a revocable trust, that allows Jeff and Whitney to be able to reach in, take the assets out, and walk away. All right. So what did I just do to this wagon? I voided it. I revoked it. I nullified it. Right? It no longer has anything in it. So I'm going to teach you a concept. Debtor creditor law says that if I have direct access to the money, so too does my creditor. All right. All trusts avoid probate. All trusts avoid probate. A revocable trust allows me to reach in and pull it straight back. That means I do not have asset protection. Okay? I do not have asset protection because we can reach in and pull it out. So, what is the primary reason that we use revocable trusts? to avoid probate. As I mentioned earlier, a lot of people want us to avoid probate. I agree, but let's do it correctly. Let's do it in a way that we don't hurt the family during life or after death. A revocable trust allows us to do that. All right. Now, let's talk a little bit about an asset protection trust. So, what I'm going to do here is I'm going to show you my board here, and I have it pre filled out, but let me give you a few examples of it. This says APT, that is Asset Protection Trust. This is RLT, or Revocable Living Trust. And this says fund money. What do you think we do with fund money? We have fun with it, right? We spend it. We do what we want with it. I talked a little bit about revocable living trusts, avoids probate. Now I'm introducing you to something that we call asset protection trusts. Now, I want to just give a disclaimer. Notice I use the word revocable and irrevocable. All right. I didn't use the word irrevocable. I'm not going to use that I word. And the reason that I'm not going to use the I word is because if you hear that word, you're going to think to research it. And if you research it, you're going to find tax trusts. You're going to find all the rules for people with more than $28 million. So you're going to find that you can't be the trustee. You can't be in control. You have to file separate trust tax returns, pay higher tax rates. It's a burden. It's expensive. It's terrible. It's only for people with more than 28. So I'm going to call this an asset protection trust. The truth is, it's not traditionally known as a domestic asset protection trust. Because when you research that, you're going to find out there's only 9 states that have them, and Pennsylvania is not one of them. That is not what I'm talking about. Okay? I'm talking about a trust that you are in control of, that you get asset protection. And how do you do that? You agree to one thing. You're not going to give it directly back to yourself. That is the only thing that is irrevocable. Everything else is changeable. All right, so now I'm still talking about the asset protection trust. Stop me if you've heard this, okay? Jeff and Whitney Belomo, trustees of the Belomo Family Trust. All right, who owns it? The trust. Who controls it? Jeff and Whitney. Jeff and Whitney can live in it. Jeff and Whitney can sell it. Jeff and Whitney can buy another one. They live in it 2 out of 5 years as their primary residence. They avoid the capital gains tax. Wow, Jeff, that sounds an awful lot like it did when it was in your name, and an awful lot like it did in the revocable trust. Why does it sound an awful lot like that? Because it is. Right? Still filing on your same 1040, same tax rates. Everything is the same. It is a wonderful tool that allows you the ability to use it, to enjoy it, to sell it, to buy another one. The reason that we have such a hard time with the concept is because we were taught a lie. Growing up, we were taught that the American dream is to own a home. No, I don't agree with that. I think what they're teaching in seventh grade civics class now is that the American dream is to be the person who has the wagon, who controls the wagon, who's the only one with the key to the house, who's the only one who can live in the house, the only one who can sell the house, the only one who can buy another house. But nobody else in the world can touch it. That's what I think the American dream is. All right. Now, this asset protection trust, the first asset that you are going to want to put in the asset protection trust is real estate. Primary residence is the first asset that's going to go in. If you have rental properties, if you have a mountain property, a beach property, they will be the first things that go in here because real estate is a great asset to put in the trust because you can use and enjoy it, still sell it, still buy another one. Okay, so it's absolutely perfect. So if I put this deed into that trust tomorrow for the house, that starts day one. Now, this is fully protected 5 years and 1 day after it's funded in here. So all that I have to do is make sure that we don't apply for Medicaid or file a Medicaid application within 5 years. And who's in control of that? We are. You don't have to worry about that. We'll guide you on that. So this goes in tomorrow. Now let's remember, Jeff and Whitney have the right to sell the property. And then if they do, they're going to show up at settlement and they're going to get money. They were the trustees. They control. They now sell it. And now they decide that they want to buy another house. Can they buy another house? You're darn right. It never had to come out of the trust. It stayed in here, which means everything is protected. We recently had a case where 7 years ago, we put one single home in a trust. They ended up needing to go to a long-term care facility. We filed a Medicaid application 7 years after we put the original house in, and they sold it. They got proceeds. They bought another one. It went up in value just by putting one house in. It was over $1 million protected in that trust, all because they got this going early on and were able to get it protected. It was exactly what they wanted and what they needed. So we're going to start with real estate. The next asset that we're going to put in the trust is going to be cash value in a life insurance policy. Okay. Why? Because as I mentioned, if you go into a long-term care facility, the cash value in your life insurance policy is a countable resource. So we're going to want to make sure that we get that protected as well. Those are the first two things that will go in. All right, now, let's say you have extra money. In a case like this, the first thing that we're going to put in is the house and the life insurance cash value. A lot of people are going to be living off their fund money. That's their Social Security and their pension. That gets put into a bank account. They might have non-qualified money, an investment account with your agent, with your advisor. And then there's qualified money. Qualified money is 401k, 403b, IRA. That has to stay in your name alone. Because if you try to put that into a trust during life, you're going to trigger all the taxes. So we're not going to do that. We're going to leave that here. We're going to leave plenty of money in your fund money to live, to do what you want to do. Now, over time, this account is going to get large. So when it gets large, we're going to start to move some of it over to the revocable trust. What we're going to want to do is protect the assets after death for our beneficiaries by getting it into the asset protection trust for them. But we can't do that with a lot of financial institutions with a bank account. So we're going to move that over into the revocable trust. This half of the board is all what you're going to spend, what you're going to live on. If we have excess money that we're not relying on a daily basis to live, we'll put it over here. You'll still work with your same financial advisor. You'll still do the investments the way you want to do them. That is still exactly the way that it is today. Okay. But let's say you put $100,000 and you're investing it and it's growing. And you're saying to me, okay, Jeff, tell me what I need to do to get that money out. Because I get it. I heard you. With this asset protection trust, I can do anything I want. I can give it to anyone in the world. But I agree not to give it to myself. Jeff, how am I going to get that money out of that trust if I need it? First of all, you're not going to need it. When we set this up, we are going to put plenty of money on this half of the board. You're going to have your qualified money, your non-qualified money. If you know that you want to go to a continuing care retirement community, we're going to make sure that we leave enough money out over here so that you can go wherever you want to go. We're going to put that excess amount above what you need to get in there over here. In 20 plus years, we have never needed to get money out of this trust and back to an individual directly. Why? Because we always leave plenty of it over here. But I know what you're thinking. I'm going to be the first person in the history of your firm that needs that money. They need it directly. They made a mistake. They had a catastrophic event. They need it out. How am I going to do it, Jeff? Okay, good question. You agree, though, that it's never happened? Yeah? Okay. And you agree that we're going to leave plenty of money that you'll never need to do this, right? Okay. Yeah. All right. Great. So now you need it. You happen to have 3 kids. Your three kids are Larry, Mo, and Curly. All right, your favorite is Larry. You have an affinity to Larry. Larry is your favorite. You always kind of gravitated to Larry. Larry was always the one that kind of did what you wanted. So you write Larry that check. I don't know. Let's call it $100,000, $50,000. I don't care the number. Larry cashes it. Larry says, "Dad, that was the nicest thing anybody has ever done for me." And you go, "Whoa, whoa, Larry, time out. You're going to give that money back to me." And Larry says, "But Dad, a gift is non-takeable. You can't make me give it back." And that's where you say, "You're right, Larry. You're right. But Larry, I can change any of the terms of the document. The only term I can't change, Larry, is that I agreed not to give it back to myself, but I don't have to give it to you, big boy. Right? So if you don't give that money back to me, I am going to go see that lawyer and I am going to write you out of my estate plan." Oof, you just disappeared, Larry. You got nothing. Because who was in control? You were. You're the grantor. You're in control. Gee, Jeff, that didn't sound irrevocable to me. It's not. The only thing that's irrevocable is you agreed not to give it to yourself. But think about it. If I can live in it, if I can sell it, if I can buy it, if I can invest it, if I know I'm not going to need it because I have plenty of money over here, why would I ever need to do this? The answer is you wouldn't. And if you did, we could still get it back to you tax free, might I add. Right? Remember the limit 13.99 million a person plus another 13.99. So because I don't have any clients that have that, if I had to, I could get 100% of the money out of here to Larry and back tax free. As long as you have less than 13.99 and as long as Larry has less than 13.99. And if you or Larry is married, it's 28 million plus 28. I am not concerned about that. So we can get the money out of here if we needed it, although that's not our goal. Okay. Our goal is to leave it there. Our goal is to leave it protected. Now, I have mentioned about this asset protection trust during life, and I've mentioned how we protect the money. And I also mentioned that after death, we are going to get any of these fund monies, non probate beneficiary items, to go into the trust for my wife, into the trust for my daughter. To the extent that we have assets in the revocable trust, into the trust after death for my wife, into the trust after death for my daughter. Let's say that we forget to get the assets into one of these items and it's left in your name alone. Well, that's going to go into your will, but we're going to have that pour into the asset protection trust after death. This is a comprehensive plan that everything's going to be tied together so that we can protect your family during life and after death. Now, here's the key. Are we going to avoid probate? You're darn right. My goal is that nothing is left in your will alone. Our non-probate beneficiary items are going to go to the trust for the wife, to the trust for the daughter, the revocable as well. Everything is going to pour over there after death. I fully believe that you love your spouse and your kids way too much to leave them money outright. Okay, I'm going to talk a little bit more about that. Secret number 3 is that most estate plans fail. In order to have an estate plan that doesn't fail, it has to honor your life, protect your resources, set your family up for success today and tomorrow. All right. Now, how are we going to make sure that we're setting this up for success today and tomorrow? Well, one is we're going to get it updated regularly. Two is that after death, we're going to make sure that those assets are protected for our family members. So, one of the things that I say on a very regular basis is you love your spouse and your kids way too much to leave them money out. And I know that at times I probably offend people, and I don't mean to, but let me give you an example. I used to manage water rooms. Now, was that a good gig for college and a law student? Right? I loved it. I hate pH. I hate chlorine. If I beneficiary designated everything to my wife, and everything's transferred automatically to my wife and my dad. Who gets it? She does. Who's in control? She does. Who gets the benefit? She does, and my daughter does. All right, so let's imagine I die. Everything goes to her. Every spring, she wants a pool. So after she grieves for a reasonable amount of time, what's the first purchase that she's going to make? A pool. And what comes with every pool? A pool boy in a Speedo, right? Yeah. Now, let me get rid of that visual for you, all right? Let's just say it this way. I genuinely want my wife to be able to buy a property. And we've always wanted and envisioned that we're going to be able to buy a property near water. And she's going to get that property. I really hope that she finds someone else that makes her happy. And I hope they enjoy it. I hope that they enjoy the views. I hope they get to see dolphins. I really believe that. But when she passes, where do I want the house to go? To my daughter, right? I don't want it to go for her to put his name on it and my daughter not to get it. So all I'm saying is I want to do it in such a way that avoids probate, but that more importantly protects it so that only my wife can access it. Only my wife can spend it. But when she passes, it goes to my daughter. Now, that's hard for some of us, and we kind of feel uncomfortable at times with that example. So let me change the example. Let's say that I'm driving down the road, and my wife Whitney and I are in the car together. I hit a tree, and I die instantly. Everything transfers to her because it was probate beneficiary designated. I avoided costs, I avoided probate. But what happened? It all went to her. Now, she didn't die in that car accident. She's going to spend the next 25 years in a long term care facility at $14,676 a month. So, did my daughter get the benefit of that money? No, no, she didn't. Let's just say I'm driving down the road, I die, she lives. 6 months later, she's driving down the road in a car. She hits a school bus or a minibus with 10 medical students going to a conference. Let's say we have $3.5 million between our auto insurance and our umbrella policy. Is $3.5 million enough to cover 10 medical students who pass away heading into the highest wage earning years of their life? No, not even close. So, did my daughter benefit from that money? No, she didn't. So I don't want to do it in such a way to hurt my spouse, to hurt my family. I want to avoid probate, but I want to do it in a way that protects the family, that allows her to be the only one who can access it, be the only one who's in control of it, but nobody else can get it. Same with my daughter. When it's time to distribute those assets to my daughter, I don't want her getting it outright. At this point, she's going to be 16 years old in a month or two. She's the most responsible 15-year-old I've ever met. Every Monday, I have to give her a printout of her 529 account, her Vanguard account. She already has enough money to buy the vehicle that she wants, pay for 3 years of insurance. I think she's going to be a pretty good kid. What do you think? So, if my wife and I died in that car accident together, and if everything was non probate beneficiary designated to her, she gets it at age 18. Do you think an 18-year-old's ready to handle a couple $100,000? What do you think? No, she is one good college party away from a stupid decision. Absolutely not. Right? I want her to be older. I want her to have access to it. I want her to be able to use it for a wedding, for health, for college, for whatever she wants. But I want to know that if she gets divorced, her husband can't take half of it. I want to know that if she goes through a crisis in her 20s, maybe she does make a stupid decision. Maybe she has an addiction. Maybe there's a gambling problem. I want to make sure that money is there when she gets better. I want to make sure that my sister can provide for her. And when she turns 45, she's in full control. My sister relinquishes control at 45 and says, Diana, you're ready to go. But here's the thing. If she thinks she's ready sooner, she can always give her control. But if I say 25 and she's going through a problem in her life and she's in full control, she can take the money and do whatever she wants. So it's not that I don't trust her. I'm not trying to keep it from her. I'm trying to protect it for her. Okay. Now, don't worry. If she has a special need, if she's receiving government benefits, we'll protect it in a special needs trust. so that she can still get the government benefits and get your money. But in my example, currently she doesn't have that. So currently, we're going to let my sister be the trustee for her until she reaches the age of 45. She'll get access to it. She can spend it. She can use it. It is exactly what she needs in order to be able to be set up for success. So we're going to protect our spouse and our kids so that only they can get. Now, I just want to ask a question. I just said that my daughter is in full control. Did I say that she owned it outright? No. Ownership is not what we're talking about. We're talking about what's the word? Control. You got it. So that's the key. So secret number three is that most plans fail. And you have to look at like traditional law firm models, right? They don't have the right tool for the job. They have a will. That's the tool that they have. So therefore, because everything that they have is a hammer, everything looks like a nail. Everything looks like a will. But those don't work, right? These traditional models, they don't provide legacy planning, they don't provide healthcare planning, they don't provide regular updates, they don't fund the assets in the trust. Funding is where you're taking the assets and physically putting them into the wagon, getting them into the trust so that they do what you want it to do. And they also don't have financial professionals on the same page. I can't tell you how important it is that we are on the same page with the financial professionals. In our office, we have permission to speak to your advisors to make sure that everything gets funded correctly. It's imperative. We're not trying to hurt them in any way. This doesn't provide any negative tax benefits. It doesn't change anything that they're already doing for you. So we want them to be on the same page, we want them to be involved in the process. So I mentioned earlier that I had just devoted myself to education so that what happened to my family doesn't happen to yours. And that has worked very, very well for 20 plus years. A couple of years ago, a client came into my office and made me realize that what we were doing wasn't working, and I didn't even know. So I'll call him Chip. Comes into my office and he says to me, Jeff, do you remember me? I came to a workshop 10 years ago. And I went to the workshop. You educated me for 2 hours. At the end of the workshop, you put up on your board three different plans. You put up a will-based plan, a revocable trust plan, and an asset protection plan. And you said the will-based plan, I'll use today's numbers, $900 for a single, $1,400 for a married couple. The revocable trust plan with everything before it, with the will, financial power, medical power, and the asset protection after death, 6,000 or 8,000. And then the asset protection plan includes everything before it. So it gives you the revocable trust, the asset protection after death, all of the wills, financial powers, medical powers, 11,400 or 13,400. So Jeff, I left the workshop. I came for the free consultation in your office. We called it a vision. He said, at the end of the hour, you did exactly what you said you were going to do in the workshop, which was ask me which of the three plans I would like, and we would move forward with the plan. He said, but Jeff, I only heard one thing, and you all heard the same thing. I know you did. What'd you hear? You heard 13,400. That's what you heard. I know you did, right? And that's what he heard. And he said, and I just was overwhelmed. I couldn't understand what was going to go where. I couldn't understand what I was going to fund here or there. He said, so I asked for a second free consult, and you gave it to me. I asked for a third free consult, and you gave it to me. He said, and at the end of the day, I did a base plan. I didn't imagine that there would ever be a scenario where spending $13,400 for something that I didn't understand would make sense. So unfortunately, my wife got Alzheimer's. 5 years later, she was wandering on the streets. She got picked up by the police for the second time and got placed in a nursing home. I didn't even know where she was for 2 days. I was petrified. And I finally found her, and I was told by my advisor to come back to see you. And I did. And I attended your crisis workshop because now I have a loved one who's going to need skilled care or is in a skilled care facility. I listened to the 2 hour workshop. I got the free consultation, and all I heard was the price. I asked for a second, I asked for a third, and you gave it to me. He said, but same thing happened. All I heard was the calls. I got overwhelmed. And I said, Chip, that doesn't even make sense to me. We would have been able to help you. He said, I know. And you told me that. You even got on your hands and knees and begged me and said, this is a no brainer. It's going to go to the nursing home. Let us help you. He said, I just got overwhelmed and I didn't do anything. So now it's 5 years later. I've lost $500,000. I went from 1.5 million to a million. And I'm here today for you to help me. And my advisor says, I can't leave until I do. And I said, well, look, we can help you. And I wish we would have done this. He said, I know, but it just got overwhelmed. So we did help. We were able to protect the $1 million that were left. And he was so happy. He hugged me. He thanked me. He was so excited about the result. Now, he did lose 500,000. So when we finished the entire process, we are now about 11 years removed from the first time I met him. He hugged me and said, thank you. And then he looked at me and he said, young man, can I give you some advice? I said, yes, sir. And he said, I partially blame you for me losing $500,000. Now, at that point, the advisor stopped and said, now, wait a minute, time out, Chip. The guy gave you 4 hours of workshops, 6 hours of consultations. You haven't paid him but $1,400, and he gave you all that. There's no other law firm that would do that. And he said, I understand that. He said, but there has to be a way for you to change the value, to change it so that I don't just hear the cost. I didn't just hear the 13.4. I actually could get beyond that. I wouldn't be worried about what's going to go where specifically because the price point was low enough that it didn't matter, that I knew it would make sense, that it would be a no-brainer. Why do you have to educate one-on-one? Those vision meetings are intimidating. I know you don't believe this, but lawyers are intimidating. Sitting there knowing you're going to have to make a decision. You educated, and everything you told me was the same thing that you said in the workshop. And I still didn't get it. I was overwhelmed by it. And I think it was because I was sitting across from a lawyer. And even after the third meeting, I didn't learn it anymore. Why do you have to do that one-on-one? Why can't you teach in a group? Why can't you bring the price point down? To which I replied, you won't believe this, but some people actually take 3, 4, 5, and 6 free consultations. And he laughed and he said, I do believe that. I did that. I said, I know. He said, but there's a way you can fix it, Jeff. I know there is. And I realized that day that I was the problem. So 2 years ago, I made a decision. We're still going to offer that model. So if you're sitting here right now saying to yourself, nope, I want to come in for one free vision meeting, and I'm going to make a decision based upon those costs that he just told me, because I want to sit with an attorney one-on-one. We still offer that. By all means, please do. But I'm really proud to tell you for the last 2 years, we offer a new model at DeLomo and Associates as well. And I know it would make Chip proud. I know that he would be happy because now we are able to bring it down to a price point that absolutely makes sense. We're calling our legacy planning solution. So we get you educated, we give you an entire toolbox, we fund it, we get those healthcare updates, and we make sure that your advisors and your family members are involved in the process and understand it on the back end so that it works today and tomorrow. So the program that we're talking about is our foundation program. This workshop is called our 3 Secrets. At the end of this workshop, you are going to be able to schedule a blueprint. A blueprint workshop is where we're going to educate for the first hour. Then we're actually going to give you a workbook, and we're going to walk you through the workbook so that you can make decisions about who is your financial power, who will be your healthcare power, where will the money go when you pass away, who do you want to benefit from it. You'll put pen to paper in the workshop. There'll be a couple other families in the workshop with you, and we'll be able to come one-on-one. The attorney will be able to answer questions. They'll be able to guide you. But before we get you in the blueprint room, we're going to schedule a right fit call. So once we know that you're scheduling a blueprint, we're going to get you a right fit call. That's going to allow you to talk to an attorney to just understand the basics, answer your questions, make sure you get all of your questions coming out of the 3 Secrets answer, and also make sure that it makes sense to have you in the blueprint. If it doesn't make sense, we will make arrangements to take care of you and your family a different way out of this process. But if it does, we will certainly take care of you. We will get you in the blueprint. At the end of the blueprint, you have absolutely nothing out of pocket to this point, And at the end of the blueprint, you can fist pump me and thank me for my time and walk out the door. Or you could say, you know what, Jeff? I know that I need this. I know that I need all of it. I don't know exactly how it's going to work at this point, but I want everything. But I don't want to pay 13,400. So the total cost for everything, if you choose to move forward at the end of blueprint, is $7,000. But if you move forward at the end of the blueprint, it is $6,500. We know that this is the right thing for you and your family, and we want to incentivize you to make a decision to protect them. Remember, there's a 5-year look back. So every day that goes by, we're one day closer to not making it. So we want to encourage you to make that decision. We want to encourage you to protect your family. And we also don't want to have to chase you down and follow up and do all that thing. So we're going to give you the $500 that it would cost us and say, please help your family, protect your family. And it's 6,500. If you don't want to, not a problem. Fist pump us, and whenever you're ready, it'll be $7,000, and we would love to help your family. And remember the example by putting that one house in, that family in our county protected $1 million. So you don't have to put a law in over 5 years to protect a significant amount of wealth for your family. So assuming you move forward, we will draft your documents based upon a workbook. You will get access to those documents and access to our classroom, where I will actually walk you through all of the documents, explain everything to you, and then you will come in for the one-on-one attorney meeting. And in that one-on-one attorney meeting, you are going to be able to ask any questions, make any changes. Remember, you've already seen your documents, you have already processed them, you've written questions down, you've heard me explain everything. You're pretty far along now in the process. And now that's where we get to talk about questions. We get to talk about funding. We get to talk about what's going to stay in fund money, what's going to go here, what's going to go here. Maybe some of you won't use this one at the start, but we'll have it because eventually this is going to grow and we're going to need it. So we'll talk about how that's all going to be structured in that meeting. We can make any changes we need. We can talk about funding. And then we're going to get it signed. That's called an implementation workshop. We're going to get that document signed after the changes have been made. Then we're going to get you into funding. We're going to take care of getting the boxes in the wagon, making sure that the assets are where we want them to be. We have a funding department that's going to assist you with that to make sure that it's all taken care of. Now, what I learned is the key is to give you a fully loaded toolbox. I don't want to just give you a hammer because everything would look like a nail. I don't want to just give you a screwdriver because everything would look like a screw. What I want to do is hand you a fully loaded toolbox and say, look, you're going to need this. I don't know when, I don't know specifically the circumstances, but you're going to need it. So let's get your family protected. Let's get it in order so that we can protect it during life and after death. And it's at a price point of $6,500 that it makes complete sense. As long as you can put a house in there, this makes sense. If you don't have a house, I would say that you would want about at least $150,000 of investable assets to justify putting them in the asset protection trust. But a lot of people still do it for $6,500, and some just fund the revocable trust and then use all the asset protection after death. That also makes sense as well. So either way, we're going to give you the fully loaded toolbox, and we're going to make sure that you and your family are taken care of. So in the old model, if you choose to come in for the vision meeting one-on-one, you would get the whole package. That cost would be $13,400. That includes the financial power, the medical power, the last will and testament, a revocable trust, and an asset protection trust. What we want to do, and what this plan will do for you, is give you all of that, but also get it funded. We're going to get the family educated. There's nothing like handing your children a binder of 300 pages and saying, all right, here it is, go get them, right? If you handed me the Steelers playbook, the Ravens playbook, the Eagles playbook, does that make me a coach? No, of course not. I'll have no idea what it means. But yet, why are we handing children binders with hundreds of pages and expecting that they're going to understand after death what their responsibilities are, what they need to do, what it means for them? So we are going to get them educated. We're going to get them informed. So we're going to educate the family. We're going to educate your advisors. We're going to give you the ability to meet with attorneys, to ask questions on a weekly basis in real time. We're also going to be able to give you continuing ongoing support. So I'm really proud to tell you that about 14 years ago now, clients of ours said, Jeff, we want to be able to call you on a regular basis. We want access to you on a regular basis. We want to have you on retainer. Remember the old days when businesses would put attorneys on retainer and they pay a small amount and they get access to the attorney? They said, we want that ability. We want you to call us when the laws change. We want to be able to get monthly events. We want our family to be educated. Oh, but we don't want to pay for anything. We don't want a bill. We don't want to get that 0.2, 0.4 bill. And I said, well, how be creative? So here we are now, almost 14 years later. And originally the program was called the Maintenance Program. It is now called the Red Wagon Club, right? Because of the wagon, and it is still the best thing that Blomo and Associates has to offer. Our clients came up with a model where we are able to answer your questions in real time. Every week you have access to primarily me every Thursday. We call it your legal hour. Our clients are able to ask questions real time, get answers in real time. Our attorneys also have time blocked out to be able to do one-on-one calls with our Red Wagon Club members. We do educational events where we educate your family. We teach them what it means to be a fiduciary, what it means to have separate share trusts, what all of this means. Why did your parents do this? What are all of these wagons? What does it mean? We'll educate your advisors. Once a year, we have a yearly event where we literally say to people, here's the changes in the law. Here's what's happening. And at that same event, we're going to get all your documents updated. Your powers of attorney are going to be updated. Because remember, those banks want them updated every 1 to 2 years. So you'll get them updated, no questions asked, no bill. Now, for the rest of 2025, you are included in the Red Wagon Club. There is no fee. So you do this plan, you get the fully loaded toolbox, you also get automatically enrolled in the Red Wagon Club. In January of 2026, you'll have a bill that will say if you'd like to remain in the program, it is $795 for ongoing Red Wagon Club support. So let's break that down. That's $795. Let's call it $800. That is 2 hours of attorney time. So a couple of years ago, the Secure Act came out, and we had to change all of our trust documents. So for the people in the Red Wagon Club, they automatically got it done. They got updated. They're good. The people not in the Red Wagon Club, they had to come in for an hour to understand the rules and the changes. They had to make the changes, so there's drafting time involved there. They had to sit with someone to sign it, to understand it. There was some back end work to getting everything funded on the back end to make sure that it was all tied in. You're looking at 4 hours of work. You're looking at a bill of close to $1,500, $1,600. And that was a change in the law. And that does happen. So while I was scared at first, when my clients wanted to create this program, it is now the single-handed best thing that we do. We have over a 90% retention rate in this program historically over the time that we've had it. Our clients absolutely love it. So you will get all of those benefits as well as a 1% fee guarantee. So when you pass away, there is a fee to administer your estate. As I mentioned, most attorneys are charging 4 to 5% in probate. If you're in the Red Wagon Club, the fee cannot exceed 1% to your family. So you will know the catch fee is the most that they can be charged. You'll know that they're educated. You'll know that you get monthly events where you can get updated of different areas of the law, Medicare, Medicaid, health, life care plan. We're offering monthly workshops, and all of our workshops are recorded in the portal that you and your family and your advisors have access to. So all of that is in there for you, including that 1% fee guarantee. For the rest of this year, there's absolutely no fee for it, and you don't have to make a decision until January of 26. Now, do me a favor, take advantage of it this year. Come to the monthly speakers, attend the weekly yearly legal hours, schedule a meeting with an attorney to kind of update, ask questions. That is all okay. Come to the yearly maintenance event where I talk about changes, talk about what's happening, what I'm learning when I'm speaking nationally. Come to our appreciation events, come to the picnics, come to the holiday appreciation. There's nothing worse than getting a call in January saying, Jeff, should I stay in the program? I'm not sure. $795. I understand that's only 2 hours of time. I just don't know what to do. And me say, well, I don't know. What did you think of the weekly calls? What did you think of the access to the attorneys? What did you think of the maintenance event, the speakers? And they go, I don't know. I didn't attend any of that. Well, if you don't attend it, it's hard to know what the value is. So my advice is take advantage, use it, experience it. And our software gets updated 4 to 5 times a year. So if something changes, we will notify you. We will tell you. We will get you in to get that change happen immediately. If you're not, you're kind of on your own to know those changes, to be able to understand that. So take advantage. I truly believe that that is the single biggest thing that Palomwood Associates does. It's proven by the retention rate over the history of the Red Wagon Club. I'm so proud of it. I'm so glad that I did it. So glad that my clients were the ones who created it. A couple pictures of some events that we've had. Absolutely, the single best thing in our firm is our clients. And many of you are sitting there right now thinking to yourself, okay, Jeff, I understand that you're running a business here, and this has to be a really good thing for you, or you wouldn't be doing it. Well, here's the truth. If you add up how many hours we spend weekly getting attorney time available, me being on calls every week, me being available, the monthly speakers, the yearly events, we actually do not make much money at all on this program. Okay, so then why do you do it? You're not stupid. You're going to do it for a reason. You're right. Because our clients become our family. We get to see them on a regular basis. I talk to them on a regular basis. And yes, I do have a selfish motive. Red Wagon Club members are 3 times more likely to refer to us than any other referral source. So we're willing to invest in you to become part of our family so that we know that you're going to trust us and like us, and you're most likely to tell your friends and neighbors about us. So it's a win-win. We get the ability to have your documents updated. We get the relationship with you. We get to know you. And in return, hopefully you'll like us and you'll tell other people about us. So that is definitely a win that we get from it. But as far as the time that you're going to use, you are going to far exceed 2 hours a year. Most people are averaging over 10 hours a year that they are using of our time, one-on-one time, which would have cost them thousands of dollars for $795 a year. So take advantage of it. It won't cost you anything until January of next year. This is an example of the portal. There is a welcome video. It welcomes you to the Red Wagon Club, tells you the benefits of the Red Wagon Club. And this is also where all of the videos, all of the events are housed. Your legal hours are there as well so that you can listen back and get your family informed, get your advisors informed. We have a great newsletter as well that will update you on different areas of the law and what's going on. Most importantly, we just want you to be part of the family. We just want to get to know you and for you to get to know us. All right. So do you want to learn more? If you do, what I would advise is give the office a call, schedule the blueprint. When you schedule the blueprint, you're going to also get a right fit call. You will have no cost out of pocket. It won't cost you a thing to attend the blueprint. It won't cost you a single penny. At the end of the blueprint, you can fist pump us and thank us for our time and the education. And I know that I honored my mother. So that what happened to my family doesn't happen to yours. If it makes sense, you want to get that family protected, you want to get a fully loaded toolbox, we'd be happy to help you. You move forward that night with $6,500, and we will get your family taken care of and get those documents drafted. On the right fit call, we're going to be able to really make sure that we answer your questions and that we make sure it's a fit to have you in there. And if not, no big deal. We'll make other arrangements to protect you. So there's no cost, there's no obligation. Another 2 hours of education allows you to really understand what it is that you're looking at and make a decision that is right for you and your family. I can't thank you enough for spending this time with me today, for being here, for learning the 3 secrets to protect your family and your legacy. I look forward to meeting you through the process. We hope to see you at the blueprint. And of course, the attorney will talk to you on that right fit call. Thanks for your time. Have a wonderful day. We look forward to seeing you in the office at Paloma and Associates. All right. So if you have gotten to this point in the workshop, you listen to the entire workshop. You know that you're going to be scheduling a blueprint and getting a right fit call to meet with an attorney to ask frequently asked questions. But I thought because there's going to be a few days that are going to go by before you're going to have the opportunity to ask those questions, I would just take a minute and answer the most frequently asked questions that we get on the right fit calls so that you have that opportunity to get those answers now so that you can go into the right fit call not asking the same questions and are able to really get into the heart of does this make sense for you and your family. All right, so the first question that we get all the time is can I put a house in a trust that has a mortgage? Yes, absolutely. I will save you all the legal technical jargon. I'll save you the name of the act. I'll save you all of that and just simply say, yes, you can put a house in a trust that has a mortgage on it. We'll talk a little bit more through the process. We'll talk to you at the one-to-one attorney review, but yes, you can. It is not a problem. Can I put my IRA or qualified account into the trust during life? No. If you put a qualified account, which was a 401k or 403b, an IRA, into a trust during lifetime, you're going to trigger all of the taxes. So during life, you will not. But at death, remember, at death, we're going to transfer all of that assets, whether it be the non-probate beneficiary designated items or the revocable trust. They're going to pour into the trust for the benefit of your spouse or your child. So at death, you can, but during life, you can't. Jeff, what if I don't make it 5 years in the trust? Look, don't worry about that. You came to this pre-planning workshop and you listened to this workshop because you believe that you or a loved one were not going to need skilled care in the next 6 months to a year. If you do think that, then please watch the Crisis Medicaid workshop, go through that, understand it. But otherwise, you're here because at this point in time, you're healthy, you believe that you're probably going to make it. We are in control of when we file a Medicaid application for you. So that 5 years only starts when we file a Medicaid application. So the reason that we want you to get this started today is to get the clock going. We've reduced the price down to a point where you're able to move forward, get the clock going, not worry about all the specific details. Let's get that house in, let's get the real estate in, let's get the clock moving. But we're in control of when we file the application. There are ways to get around it, there are ways to protect it, but the closer we are to 5 years, the better. So let's just get it in, let's get that clock going, and let's not worry about that. All right, the next question is, Jeff, are there any other uses for these trusts other than asset protection? Wow. How much time do we have? Right? I can't even begin to answer that question. We're going to avoid probate. We're going to save all the costs uh, for your family in the probate process. We're going to protect your family after death so that the money can only go to your spouse and your kids. If you remember, too, what we said in the workshop was we're going to fund these trusts in such a way that we're going to be able to get you into the CCRCs. We're going to be able to leave money out to get you where you want to go. We're just protecting that excess money so that we're in control, so that we have flexibility, meaning you and your family. If we end up needing more money to get more care in the home for you, we can access that money. If we need to provide something for your family, we can access that money. If your kids need money, if your grandkids some, we can access that money in that trust. That trust allows that money to be protected for you and your family only, not to lose it to long-term care. But if you need it, we could get it for the benefit of you and your family. It provides flexibility. It provides control. So no, it isn't just necessarily to do that. It is also to let you and your family be in control. What if I want to go into a CCRC? Again, we're going to make sure we leave plenty of money out. If for some reason we don't leave enough money out because we miscalculated or you didn't think you were going to go to a CCRC or the rates go up or the amounts go up, we can still access it through the trust if we needed it. So again, that trust provides the flexibility. We'll make sure that at the time you're going to fill out the application that you have enough. Jeff, I need you to confirm that I'm not creating a tax problem for my kids if I give them the money out of this trust. So, Jeff, my Larry, Moe, and Curly, if I give them money and they give money back, am I going to cause a tax problem? No. As long as you don't have more than 13.99 million, your spouse doesn't have more than 13.99 million, and your kids don't have more than 13.99, and their spouses don't have more than 13.99. I'm going to go out on a limb, and I'm going to say that's probably not the case. So, no, you're not creating a tax problem as long as you don't have more than those assets. Jeff, I'm 85 years old. It's too late for me. No, it is not too late. What do I care more about? What is your current lifestyle? Do you feel healthy? Do you think you're going to need care in the next 6 months to a year in a nursing home? If the answer is no, the probability is this is worth it. We have 95-year-olds who created a trust and who ended up protecting assets. People are living way longer today. And unfortunately, that also means that people are needing long-term care a lot longer. So we want to make sure that we protect against that long stay in the facilities. And how do we do it? We get the clock started today, right? So age doesn't matter. We have 65-year-olds who are in a nursing home. We have 45-year-olds in nursing homes. Age isn't what we're worried about. We're worried about, do you think you can stay out and take care of yourself for a year, right? 2 years. If the answer is yes, then at least proceed with the right fit call, with the blueprint. Let the attorney know on the right fit call your concerns, and then he or she can then direct you if we need to take you a different route. But age itself has nothing to do with it. Jeff, can I bring my spouse to the blueprint? Yes, and you should. We would much rather have your spouse there. It's very difficult when a spouse isn't present. If there are health reasons, if it's impossible to get them in, just let us know that. We can certainly make arrangements. But assuming that both of you are able bodied to get in, you definitely want the spouse to be there. Now, the fact that you asked that question tells me that your spouse is not watching this video. So that means that they need to. We cannot have anybody in the blueprint who has not watched this video or attended this workshop live. Why? Because it's too overwhelming. Could you imagine the first time you're hearing this is the next workshop when somebody's asking you if you want to move forward, if you want to fist pump me and you're going to write a check today? No way. There's no way that that would be able to be something that people would be comfortable with. Certainly I'm not. And also, it really blows up a room because if you haven't heard this, you're asking really basic questions that other people in the room know, and it's slowing us down. And it really is a full 2 hours. So we are on a time. So make sure that they're watching it. You have an advantage. You can hit that rewind button and watch it back. So you can watch this as many times as you want, get your questions answered, come into the blueprint, make sure your spouse watches it as well. Same question with your children. That's up to you. What I always tell people is if you're not going to make a decision, if your kids aren't there, bring them along. Now, same rules apply. They have to watch this workshop. But if you're like, no, I'm an adult, I'm going to make a decision for myself, and I'm going to do what I think is right for me, I want to get them educated later. I want to make sure that they understand it, the process, they understand what we did, we understand what it means. But right now, you decide who's in that blueprint. The only rule is if they're in the room, they have to watch this workshop so that they have the background. All right. Can you review all the documents in this plan one last time? Of course. It's a fully loaded toolbox. It's a last will and testament. It's financial power, medical power. Living will is embedded in the medical power. That's called an advanced healthcare directive, revocable trust, asset protection trust. And you're also going to get it funded and you're going to get all of the beneficiary designations over into the asset protection trust for your spouse and your children. We will do the will that will pour into the trust as well. So you get everything in this plan. When do I schedule my blueprint? You can schedule it now. Give us a call. Go ahead and schedule your blueprint. They're also going to schedule that right fit call. If this is not the best use of your time in the blueprint, the attorney will work with you on that. We will be able to guide you in a different direction. If there's other planning you need, we'll be able to help you with that as well. But getting scheduled for the blueprint, no cost, no obligation, get you that right fit call, which will allow you to ask your questions further beyond these questions and make sure this is right for you and your family. Thanks for taking a few extra minutes with me to talk about the frequently asked questions. We look forward to seeing you at the blueprint and in and around the office of Homeowner Associates. Till next time, see you real soon.